Okay, it shows that we have all 5 members of the committee, as well as Josh is with us, is keeping us organized, and Tom Stoss is showing as a guest. So Josh, let's go ahead and start. I'm going to call the meeting to order at 1:03. First item on the agenda is approving the agenda. Are there any comments, deletions, additions that desired to be on the agenda?
I see none.
Okay, if there are none, I'm going to consider it to be approved. The next item on the agenda is the approval of the minutes of our last meeting, which is the December 17th meeting. They've been previously distributed. Does anybody have any changes, additions, deletions, corrections, that sort of thing?
I don't.
No.
If there aren't any, I'm going to show those as approved. And let's continue on here. We try to keep organized. There aren't any public on here showing as signed on, with the exception perhaps of Tom Stoss. Tom, if you have any comments you want to make at this time, feel free as a member of the association, or again during our meeting, if you have something that you feel needs to be clarified or want to ask a question on, feel free to do that in case I forget, which I usually do at the end of the meeting, to ask if any questions from any of the media that are present. But I don't see any public comments, so let's continue on with the agenda items. Josh, if you could put the agenda up, please. Okay, let me clear something out of my way here. Come on. No, can't do it. Okay, the first item on the agenda. Well, first, let me make a comment, a more general comment. The first 3 items of the agenda have quite a bit of overlap. And we're going to have to play our way through that as we continue on to where we make crossover from one of those items, the first 3 items, to the other. And it's just an observation at this point in time. And I've asked Steve if he would lead us off on the first agenda item, which is the charging document. And Colette, when we get to the next item, which is the resolution MO9 drafts, if you would also, when we get there, lead us on in the discussion of that item. And again, as we feel necessary to go back and forth between the 3 items, let's do so. And I recognize we do have a lot of perhaps a lot of overlap. At any rate, Steve, if you would take over here on that first agenda item, the charging document.
Okay, thank you, Jim. I hope you all received the document. This is based in large part on the work that Keith and I did together. And I want to, when we sent out the changes to Article 5, we also included a draft of a new document relating to what a candidate for the board of directors would fill out. So let me start, and I apologize at the beginning for, if you went to the end of the document about Article 5, you'll see an explanation, and I apologize for not putting it up at the front, but my word processing skills are severely limited, so we'll leave it at that.
Steve, is this the correct attachment?
It appears to be so, yes.
Right.
So let me start off at the top. You'll note prior to any change in this section by section, there's a paragraph in red, and there's an explanation for that. I mean, basically, when Keith and I talked about this a little bit, I felt it was important that in light of the court case, which was still pending at the time and is now at least temporarily been resolved, it was important that everyone be on the same page, that when you're talking about the eligibility and the duties and the election and the method of operation, broadly speaking, of the board, that this is the section to be looking at. Again, if you had an opportunity to read the judge's opinion and order, he did sort of bounce around a little bit, if you will, between the charter and other sections of the bylaws and that sort of thing to reach the decision that he reached. And it struck us that it would be worthwhile to draw everybody's attention. This is the section you should be looking at. So that's why that's there. Scrolling down to 502A eligibility, you'll note that we broke it out into, I guess now, 5 separate subsections, and in large part, I think this was, as I recall our conversation, this was Keith's suggestion, and I think it's a good one. That if they were just sort of lumped into one paragraph by itself, it would never be clear that these were separate and identifiable requirements that each candidate had to meet. And you'll note, I believe I'm correct on this, all of these are shall or must language. In other words, these are requirements. This is not discretionary. Again, the idea was to, in part with an eye to the pending court case, to identify those areas that needed to be addressed. I will just tell you that in 502A2, where it says notwithstanding the provisions of 301C of these bylaws, that is the language that we pulled up from the prior eligibility charging document that we had to clarify the distinction between the time when the assessments were paid if you were a candidate versus just a member. And so I just took that language in whole and dropped it right in there, recognizing that no one has taken any other action on that particular provision. I would go on to just at, I think we captured all of the suggestions about eligibility in one form or another. We also dealt with the question of owner of record. And again, in light of the court case and the opinion of the judge, if this provision was in the bylaws and had been followed, some of the controversy could have obviously been avoided. So that's essentially where we are with that. There was I think it was in Director Daly's original draft, there was a provision in there regarding pending litigation, 3-year residency requirement. The litigation issue is dealt with in part in the registration form that Keith took the lead on. And we can discuss that a little bit more in a moment. The other note, we didn't attempt to deal with the 3-year issue. My recollection of the discussion we had last month was that was, for a couple of reasons, a difficult one to just sort of drop in there. It in a lot of ways, for lack of a better term, it didn't make sense to us. So we just left that off. The other thing that I will tell you is you'll see at the end below 50, make sure I get this one, 502A5 in the blue ink, there's a note in there about traditional forms of legal ownership. And I will freely admit to you that I took one course in property law in law school. I did not enjoy it in the slightest. And the only question that came up in our minds when Keith and I were discussing this was whether or not traditional ownership titles that are granted in property law, which goes back to English common law, would be affected by the eligibility requirements, in particular the language in sub 5, which talks about corporate entities. So I put that in there only to flag that for a better lawyer who is not retired like myself to go through and just make sure we've not created a little bit of a hornet's nest. So that's just a note that someone needs to take a look at. And I think we've dealt effectively with the potential issue, which we discussed at last month's meeting, about the potential for a conflict of interest between a business or corporate entity owning property and a representative of that corporate entity in any form serving on the board. And that's essentially what sub 5 tries to get to. Dropping down to I'm sorry, 502C. Does anybody have a question or a comment? Because I don't know that I should go through it all at once, or we want to break it down piece by piece. So if anybody wants to pipe up, go ahead.
So I have a comment, Steve. This, I don't know if you guys have communicated with Frank Daly, but he will be consulting with Jeremy and his firm on these exact issues. And so I think after your meeting today, this will need to be forwarded to him to receive their advice as to the actual bylaws, you know, how deep we're going to go with this, or did you guys already consult with Jeremy on this language?
No.
No, we haven't.
I would like to ask, why wouldn't Frank come to us, our committee first, and say, hey, I would like to take some of these issues to our legal counsel. Do you have anything at that time? Because this obviously all goes together.
Yeah, and
instead of having him and we find out maybe after the fact that he's going, you know what I mean? It would be nice if a director would reach out to the committee first, so that we're not wasting everybody's time, you know what I mean? Including the council who's charging. So,
exactly. Yeah, you raised a good point on that, and that may be on me, that Frank assumed that I was going to be conveying that to you guys. I have to say that, you know, I have not been as on top of all of this as I probably should have been. But I think, you know, this is great stuff that you guys have, and I will definitely forward it to Frank. And I think the concern that Frank has is expediting this. And so I did speak with him today, and I told him that at the end of this meeting, I will be sending forth to him information that comes from these discussions, because I believe that he's going to be talking with our council in the next week or so with the intention of maybe bringing this all to the board in our January meeting, possibly, which is the 22nd of this month. So at any rate, I apologize for, you know, if any toes have been stepped on. And I think that this also pertains to the candidate registration form that Keith has worked on, that I had worked on it also. So I think we're going to have to blend some of those revisions. Keith's looks great.
Yeah,
I have to say.
if I may, in response to your question, I have not sent this on to anyone. That's the first thing. The second thing is, particularly since I don't know what or any, and I'm not saying I need to know, but I don't know what decisions the board's going to make regarding an appeal. But putting that aside for just 1 second, if it would seem to me that if the board was inclined to consider an appeal of the court's decision, which they're entitled to, at least to take it up to the Court of Special Appeals as a matter of course, it would be wise for the board to consult with an expert in Maryland appeals process, but also covering the question of the impact of remedial actions on that appeal. In some instances, when an entity takes an action to remedy a problem, it may or may not be admitted into evidence, for lack of a better term. And I don't know if the board were inclined to take this up, or frankly even consider it, whether that would have any impact on the appeal if the board decided to take an appeal. So I just, in the board's discussions, I think it's worthwhile for them to secure an expert legal opinion, probably from somebody on the faculty at the University of Maryland Law School or something like that would be my suggestion.
Yeah, Steve, there are still a lot of moving parts here, as you might be aware. And Jeremy's firm, the firm that we contract with, has Court of Appeals experts. And so my assumption is that he will be consulting with them in whatever advice he gives to us. So, again, this is all kind of not really even off the press yet.
Right.
It's all in process right now.
Got it.
Keith?
So if I may, with regard to the issue of expediency, because we were already working on bylaws updates, which had started before this. So it's something that we've been working on for a number of months now to bring the bylaws up to date in a number of different areas. We were already working towards a referendum because all of those changes, once the board decides to move forward with them, they're going to have to go to a referendum. So we already have a referendum in our future. And I'm not sure if Frank understands that, because I doubt we would have two separate referendums on this. My belief
that Frank is aware of it, and he is aware of the discussions that you've had in your committee about the piecemealing the questions in the referendum, that it's not an all or nothing. And so the board, I've kept the board apprised of that, including Frank. And so, we know what we're facing.
Okay,
what
good.
we want to do is expedite the referendum process. So have the language ready, as soon as practicable to move forward with the referendum process.
Right, good. So, because at the end of the day, that's what this will be. It will be a bylaws change. And I don't think we want to have two different referendums on bylaws changes. So to Frank's, to the benefit of what Frank's trying to do, we already had a head start on this, working towards a referendum.
Colette, a couple of questions. Did I understand from your comment that there is a recognition or possibility of being able to vote on vote on specific bylaws provisions individually as opposed to a complete package? Has that been considered by the board?
Not formally, but the board has been in discussion of that as a possibility. But
okay.
So I think partly what we're going to be kind of waiting for is the whole package to be ready to send to council, and then receive advice of counsel on how to actually execute this referendum, what would make sense legally and practicably.
Okay, now, with regard to Frank's proposal, is he trying to get through what he has proposed or is proposing to be applicable to the coming election?
No bylaws change is going to happen in time for that.
Okay, well, I agree.
So the only thing that I think is possible to impact the upcoming election are the changes to MO9 and the candidate registration form.
Yeah, I agree. I agree.
Yeah.
I just wanted to clarify that. That's all.
Yeah.
Okay. Okay. Steve, back, are we, are there any, again, Steve stopped at his initial comments on section 5 down to the search committee. Are there any comments before we continue on with that? Okay, if not, I'd like to add my own my own comment. I would like to see owner of record deleted from the bylaws. I don't believe that it belongs there. In my opinion, it should be member should be substituted for owner of record with a further definition of owner. And I'm in agreement with the addition of as in the Worcester County land records. But I would, I'm not going to go, I'm going to try to avoid going into a long discussion here, but I believe we should be focusing on member, because that's where this all starts. It starts in the Declaration of Restrictions, reference to how you become a member. And nowhere else in the governing documents from the DRs down through the charter and into the one place in the bylaws do we talk about owner of record. I don't think it's consistent to use owner of record when we should be using the term member. Member is used all throughout the bylaws for any number of governance reasons, and we should stick with member. Now, I would go further than what's stated here in my definition of member. I would consider a member to be a person who has been granted or conveyed in a deed recorded in the Worcester County land records of fee simple interest in a lot that is a part of the general Ocean Pines subdivision. And I recognize that would have an impact on, if it had been in the bylaws before this litigation, I believe that the litigation would have perhaps not occurred, but that's so be it. At any rate, I just want to leave it at this. I think we should delete owner of record and go to a definition of member.
Jim, how is the definition of membership dealt with when it comes to corporations and LLCs and such?
Well, Steve may have a comment on this as well. It's my understanding from the code that partnerships, LLCs, and corporations can in fact be the fee simple grantee of property. So that would make the entity the member. Now, I didn't say this in my initial comment, but I would also go on further and in a bylaws revision to indicate where there is a member relationship or a member exists, but which cannot be a member of the board of directors. And among other things, a member of the board of directors would be required to be a natural person. I would further get into areas of fiduciary relationships not being eligible to be a member of the board of directors. But again, it's my understanding that corporate and partnership entities can own property that would make them a member of the association, but there would be exclusions as to regarding how that could be represented or couldn't be represented as as a member of the board of directors. And that would be my approach. Let me put it that way.
Got it. Thanks.
If I can, I'm assuming, and I freely admit I'm the new guy on the block, but I'm assuming that when the bylaws were drafted, there was a affirmative decision made to make a distinction between a member of the association and someone eligible to serve as a director of the association. I'm not sure whether that is justified one way or the other, but frankly, if you were just to delete the term owner of record in 502A1 and just say all candidates must be members as listed in the records of the Worcester County and or SDAT, there clearly would be folks who could lay claim to being member who would not appear in those records. And on top of that, you don't address, I think in that case, the issue of trusts, which is sort of at the root cause, or one of the roots, if you will, of the litigation that we're all talking about. And if you read the order and opinion, there is this sort of, for lack of a better term, in my opinion, tortured reasoning, which comes up with the conclusion that Mr. Farr was a beneficiary of the trust as opposed to being a named trustee. So I'm not saying Jim is wrong in any way, shape, or form. I think if you decide to move from making the distinction between a member of the association and the eligibility of someone to serve on the board, you invite a lot more ifs, ands, and buts than you may want to.
Steve, I'm not sure I understand I'm not sure I understand the reference to member and relationship to the board. I can't remember exactly how you phrased that, but I'm not sure I understand. I don't understand. What my definition of member is you specifically are named in the deed. That's the meaning of referring to fee simple. And I realize that maybe referring to fee simple has its own problems. Again, I am not at all experienced in property law, and that's one of the things I think that may have been missing in some of this litigation. But that's beside the point at this time. I am looking for member to be that person, and person means the person as defined in the real property article, and that includes individuals, that includes corporations, partnerships, administrators, executors, personal representatives, and so on. It's that person that is named by name in the deed as taking a fee simple interest is the member of the association. Well, again, I think that's if you go back to the DRs and go forward from the DRs to the beginning of the DRs, or start at the beginning of the DRs and work your way back to that provision, I think that's a persuasive, to me anyway, persuasive argument that that's the way it should be. And again, I want to go back and say that my understanding, my interpretation, my reading of the DRs, legal title, equitable title, all that is in reference to is the security agreement situation, that it is the equitable title person in the surety or security agreements circumstance who is the member, and that's all that legal title, equitable title provision there applies to. It doesn't apply to For example, the contract buyer, the contract seller of a property with regard to them being equal, equitable, one being the equitable owner, the other being the legal owner. And it does not apply to the equitable owner consideration within a trust in particular, especially one who is not a primary beneficiary of the trust. The primary beneficiary trustee situation can be dealt with a little bit differently. And again, we're getting much further into this than probably I want to or think we perhaps at this point in time. But again, that's my approach to changing the owner of record to read member. And doesn't have to say member as listed in the records of Worcester County. It just says member of the association. And if we're going to put in there for what length of time, fine with me. Right now, it's like 4.5 months to January 1st.
So Jim, if I'm here understanding what you're saying, you are wanting to recommend to the board and have considered by our council that we change owner of record to member, and that for the purposes of serving on the board or running for the board, that there may be some exclusions to the broad meaning of the person specifically named in the deed when you're, and I guess that again, I'm not a lawyer, I'm a layperson, so even the vocabulary is not at hand for me to speak in your language. But trustees, owners of LLCs, you know, those types of individuals who may be members may be also there, that we may consider language to exclude
Who are you dealing with?
in the exclude as eligible to serve on the board. Is that what you're saying?
Yes.
Okay, and so I think it makes sense to have that conceptual recommendation put forth without your committee having to go through the work of figuring out what those exclusions would be, because I'm guessing there's probably case law or other, you know, legal expertise that would help tease out what is possible and what is not possible along those lines. And so I would just say that instead of putting a lot of effort into your committee trying to make those differentiations, to, if your committee agrees on that general concept, that a recommendation from the committee come forth with respect to that concept, and then let our lawyers, our counsel that we contract with, kind of hash out the details of what's possible and what's legal.
Okay, with regard to this particular area section that we're talking about here, I would have no problem. Let's proceed with what Steve has here, and I could make a separate submittal of my own with regard to that.
Yeah, Jim, that's actually what I was going to, well, I don't care whether you make two separate proposals as it applies to 5021, which I guess is really where you're limiting your comment to.
That's correct.
A1, I should say.
Right.
And I have no problem in kicking that over to council to determine whether or not limiting member as defined in a fee simple deed is sufficient, in addition to these other criteria, to meet what the board deems as essential. My initial point was simply that at some point when the bylaws were drafted, there was an affirmative decision made that there was a difference to be taken into account between a person who, or any entity, whether it be a person or some other entity who is a member of the association versus one who serves on the board. And that's really what I was trying to get to. But I have no problem if you put something on paper or pass it on, however, and let council try to work through the two. That makes sense. Fine.
I'll go ahead and do that. If I understand correctly, Colette, you will be you will be forwarding this to council for his review as well. Is that correct? The Article 5, what we're going through on the screen right now.
Yes, and then any changes that you guys make today would be incorporated into whatever I send. So there
Okay,
may
and
be a little bit of homework after this meeting to get it ready.
Okay, and I'll provide you and the rest of the committee with my own separate comments. Let me very quickly, Steve, go back to what you were saying. I think in a prior meeting, it was noted that the owner of record provision appears in a comprehensive review and amendment of the bylaws that dates back to 1982, and it remained unchanged until well, it's unchanged through today, as a matter of fact. And I've tried to look back in records that I have to see where that originated, and it's not. I can't do that. I've attempted to find records for the bylaws that go back prior to 1982. I've done that recently, and that's been unsuccessful to the point that one of the efforts to find earlier records found a file copy dated, or not dated, says something like bylaws 1968. But that file copy could not be opened, including by the IT people at the association level. Whether it's the original bylaws or amended up through some period of time is not possible to say. So at this point in time, we can't go back prior to 1982. There is some evidence of sorts in the charters. The initial incorporators were, of course, the first 3 board members, and it's unlikely that either of them were property owners. It's always possible. One had a post office address for Ocean Pines. The other 2, one was Palo Alto, California. The other was Rosemont, Illinois. There was a 4th director appointed about 1971, and his address was Baltimore. A 5th position on the board was created about 1973, but not an appointed person. So somewhere in there, the bylaws apparently were picking up, if not from the very beginning, at least, were picking up director criteria as far as who could be on the board and all that sort of thing. That's as much information that I think we're ever going to come up with, other than the fact that since 1982, for sure, the owner of record part has been there as a separate item in the eligibility to be a candidate.
Keith?
I think I understand where Steve's question is based, and I just want to make sure I clearly understand what you're saying, Jim. So I'm going to paraphrase, and correct me if I'm wrong. I think what you're saying is that in the definition of membership as provided by the DRs, this issue of property ownership is addressed in some fashion or another. And by us addressing it here again separately in this part of the bylaws, we're potentially setting up a conflict. So I think what you're saying is, let's not do that. So for the purposes of definition of membership, let's stick with what exists in the DRs. And then if we want to put exclusions on top of that, like it has to be an actual person, it can't be a corporation or an entity, we can do that. But let's not bring up the issue of property ownership separately and again here in the bylaws when it's already been provided as part of the definition of membership in the DRs. Did I get that correct?
Yes, you have. The other thing I would add to it is that the definition of membership must be consistent with what is said in the DRs, and that's right. That has to be explained.
So I'm totally with you on that. You're probably one of the few people in this group that knew that. But I completely agree, because you're always going to get in trouble if you start to try to repeat things that have been previously defined versus just referencing them. So I agree with the idea that that first paragraph, Josh, if you could roll up to subparagraph 1 there. So basically right there. So basically what we're talking about there in subparagraph 1 is essentially replacing that entire paragraph with language to the effect of you've got to be a good member in standing, which is already defined in the DRs and includes the concept of property ownership. And then in addition to that, in addition to being a member in good standing, and if you wish to run for the board, there are also these other potential inclusions or considerations, which is what we would continue to address here as additions to requirements to be a board candidate.
Jim, can I just ask one other question? I'm just curious, and I'll defer to your expertise on this. But in all of the DRs, is the definition of member the same throughout?
I'm pretty sure I've gone through each of them. The only variation is how there's an expression, how the security agreement situation is expressed. It's expressed somewhat differently, but the intent or the context is the same.
Okay, I just, that's fine. Yeah, I mean, I have no problem if both are submitted to council for review. That's fine. I don't have a problem with that.
Steve, I didn't, hang on a second. I guess at the end somewhere you say you didn't address the time by which the person becomes an owner of record. We have the January 1st of the year. Is that in here somewhere? Have I missed it, or did you leave that out?
I did. I certainly did not intend to change it.
Okay.
Hold on. Let me. Where?
I think what made
That's still in subparagraph 1 at the last line.
Okay.
Okay. Yeah.
Yeah. I don't have the bylaws open in front of me. Okay. Fine.
Yeah. I certainly didn't intend to change it. That's
okay. Okay, I understand. No problem.
So moving down to, I think we can go down to 502C.
Right.
And I'm going to do this a little bit from memory, just picking up on part of what was in the original Daily proposal. This deals with candidate applications. And again, I think it's fair to say that when Keith and I met and went through this, we sort of came up with the idea that whatever the change in this section of the bylaws will be ultimately, or at least proposed, it should tie into the application itself, so that if you remember the discussion in December that we had, there were some issues that we felt should be specified in the bylaws relating to eligibility. There are others, such as, I remember some of the discussion about a felony conviction and pending lawsuits or filed for lawsuits and those sort of things. And we felt that if we could tie the use of the application into the bylaws specifically, that some of those issues could be addressed in a way so that the voters, the members of the association, could determine whether or not that's important to them one way or the other. And so that was part of what we tried to get to here. They're obviously required to attend, their full name to avoid the junior, senior type problems or whatever. And the provision of appropriate documents, particularly as it relates to trusts, again, with an eye to the litigation that was pending. I don't think we changed the timeline at all. The other language that we included again, ties back to the application form itself, so that the candidate is aware that if they're included in the list of eligible candidates, that the information provided in the application becomes available electronically or by any other means to the members of the association. You know, I guess there's other ways to get it. I mean, you probably could include something in the application about under pain of penalty of perjury, but I don't know that that would even be applicable to someone filing an application like that. So the idea was there are some issues which might be important to the voters, but need not be addressed in the bylaws, and that's sort of how we tried to tie the two together. If you remember in the original proposal that Frank Daly circulated, there was a provision in there, as I recall, about consulting with counsel. And I think we talked about this at the December meeting, and I think, Keith, tell me if I'm wrong, but I think you and I both discussed it as well, that it didn't make sense that a candidate filling out an application should have to go secure legal advice. And if that same person went to the board's counsel, you have an immediate conflict of interest for the counselor, for nobody else. So we basically just struck that out entirely because it frankly didn't make sense. And I don't really know which counsel Frank Daly was talking about anyway, whether the candidate had to go get counsel or he can go to the board's counsel, but it didn't, either one, it just wouldn't work. So we took that out entirely. We also, obviously, dealing with the corporate entity question, we dealt with the other problem about potential conflicts. Does anybody want to say anything about C?
I just want to clarify real quick, compelling the candidate to seek counsel is what we're saying doesn't make sense. Obviously, if the candidate wishes to go seek counsel because they're not sure what they're doing or what the questions are, anybody can go, get a lawyer anytime. That's completely up to them. What we were debating is whether or not it was appropriate to compel them to do it no matter what. And we'll talk a little bit about, I think, why that was probably suggested when we get to the form part of it, but that was the context under which Steve and I were talking about it.
That's correct. Thank you, Keith.
I would agree that I don't feel that we should compel any candidate to seek counsel just to submit the application. Because if that's the case, then each one of us should have been compelled to seek counsel to submit an application to be on a committee. I mean, how far down the road are you going to, do that? So I definitely don't feel that part is required there. But like you said, Keith, if the individual already has counsel in their corner or, and wants to utilize that, that's fine. But why would we want to I feel that would be a deterrent. We wouldn't get very many people to even consider running if they've got to do that right from the get-go to even put in an application. So I think that's good to not put that in this part of it,
Yeah, I really think it had to do with lessening the vetting workload on the secretary, which we're going to talk about here in a minute. I think that's really where he was going with that, but I think there's a different way that can be done. So
yeah,
I agree.
Just one or two comments. One comment that I probably should have made before. At several instances now, and perhaps continuing a little more as we continue on, we've made reference to Frank Daly's proposal. Unfortunately, the only people who are going to be able to see that in this meeting are ourselves. All of that's been previously distributed, so and looked at in some degree already. what I will do is put the information in some manner. It's in emails. I'll extract it from emails and make an attachment to these minutes so that there can be at least seen historically what we're talking about when we refer to what I'll call the Frank Daly proposal.
Okay.
The only other comment, Steve, I have up in the third line, application form as developed. It should be as developed by board resolution. The elections committee is not involved in it.
Okay, yeah, we talked a little bit about that as well. That's fine. By board resolution?
Yeah.
Okay, let me just,
That'll come up a little later when we get to my search committee item is third down in this if we get there this afternoon at any rate.
Okay.
So does that mean that the board could develop a different candidate application form every time there's an election?
Yes. The bylaws simply say, well, I'll have to open them up here to see.
So if you're saying then if we get a really good one finally that covers everything in 2 years and a new board decides, you know, we don't like that one, we're going to go back to the application that caused all the problems, they could, is what we're saying?
Yeah, as it stands now, there's a little bit more to this than what I just said. Each member.
I mean, I think we could recommend that, you know, just like in bylaws, or I'll say from my PTA experience, you know, we have to update things every 3 years. So I don't see why it wouldn't hurt to relook at applications, relook at all of this stuff. But that doesn't mean that it all necessarily needs to be changed just for the sake of changing, you know?
Okay, well, let me take this one at a time. The bylaws provisions in 502C starts out, each member who desires to be a candidate for election to the board director shall complete an application form provided by the search committee. Well, a decision was made some time back. We're going back to the creation of the search committee resolution M09 to include that form, an application form in the resolution as an attachment, I believe it's called an attachment, to maintain control over the form. So it wasn't a form that could be created and changed on the fly, so to speak. So that there was an original decision going back now 10 years to include that form in M09. Now, of course, has been revised maybe twice now, twice in maybe the last 4 or 5 years. But it's been revised by board resolution. Now, as far as it being periodically reviewed, it is one of the resolutions on our governance document review program, and I guess it's probably I think it shows every year. I'm not sure that resolution should be revised, or not revised, but reviewed. But at any rate, we show at least no more than 2 years review cycle. The resolution itself could have a provision put in it that it shall be reviewed every 3 years or 2 years or whatever length of time we want to do that.
So in other words, it's part of the resolution. So it's an attachment to the resolution. So in order to change it, they would have to update or change the resolution. They're not just going to create out of whole cloth a new application form every election.
And it's subject to the standard board resolution revision process.
Gotcha.
First reading and then a additional consideration and adoption type process.
Got it.
well, let me ask a question. Does that then require us to include some language in this change to the bylaws that makes it clear that the board is expected to include, and I'm just I'm not tying this language as being the one we have to use, but basically make it clear that the issues that we add to the application that we've discussed as part of the application that Keith drafted should be included in any application. In other words, they can add to it, add other considerations to inform the voters, or they can change the format, but those issues, you know, that we feel are worthwhile about, however they're phrased, felony convictions and criminal indictments and all that, should stay in any application. I mean, I'm not even sure how to go about doing that. I'd have to think about it, but do we have to include something making it clear that that ties it all together?
Do you mean making something clear in the bylaws that ties to the application form?
And broadly speaking, yes, that's the question.
Okay, that's a good question. I'm not sure I know what else to say. Going back some 10 years now, there was a situation in which an election resolution, that's M06 provision, conflicted with the bylaws. And that was referred to the then Association Attorney Joe Moore. And he said that it did. And he established that I have it here somewhere. Here's his general comment, not general, I'm sorry. In the particular case before him, he stated the issue then is whether or not the inconsistent provisions of the resolution must yield to the provisions of the bylaws. And in my opinion, such is the case. So if the resolution is inconsistent with the bylaws, then the resolution provision is not valid. Now there's another part that I wanted to refer to here. Okay. He further on in kind of a concluding statement, he says, because the bylaws are the stated authority for the resolution, the provisions of the resolution must comport with the bylaws requirements. Now, you can probably spend half hour or more trying to figure out how best to say that other than the way it's said there. The way I look at it is that the resolution cannot change the provisions of the bylaws. And I think that was what he was getting at in the particular issue that he was dealing with. So that's the way I look at what you can do with something in a resolution. And we're talking about here now the application form. As long as we're not putting something in there that conflicts with the bylaws, we're okay to put it in the form. Now, what you put in the form also has to have some kind of at least reasonable application to purposes of the association. That you can't just throw anything into the resolution. It's got to have some test put to it as well, in addition to being simply consistent with the bylaws. It's also got to have some kind of a reasonableness about it.
Right.
I don't know if I've answered what you're talking to or not.
In part, you have, Jim, but I guess the question I'm asking is whether or not, in the collective wisdom of the committee, we should look to be able to put some language into the draft that we've prepared for Article 5, some language in, I assume it'll probably end up being in C, for lack of a better term, instructing the board that those issues relating to character, or however term, I don't know what the term would be, should be included in any candidate application form. In other words, what you read, Jim, was if there's a conflict between the form and the bylaws would supersede the application or the board resolution, which makes sense. But as currently drafted, this draft does not capture those issues that Keith amended the application with. I think my language is bad there, but that's the issue I'm getting at. In other words, should we look to find a way to put language in C that ensures that those character issues that we put in the application stay in any future application?
Okay, I don't have a good comment other than that. That's something that the attorney probably going to have to give some guidance on. Could we? I mentioned earlier about a potential overlap between our different agenda items. Colette, there are some items in the proposal that you have, the application proposal you have that fit within this kind of thing, as to whether they can really be in the form without there being some bylaws authority for going into that kind of detail. Among other things is that, of course, the criminal record kind of question, and also there may also be a question regarding whether or not the disclosure of the form after the candidates have been established, whether that can legitimately, I'm going to say, legitimately be in the form without there being something in the bylaws. That kind of question would be going to, if I understand correctly, we're going to get to your part of this, but if I understand correctly, it's your intention to have this go to Jeremy prior to the January 22nd meeting.
That's correct.
Okay.
And I think, again, with respect to the advice that your committee would provide, I think this comment that you're making about the form be reviewed to ensure that it does none of the information required or considered, that none of that is in conflict with the bylaws or the charter or the DRs. That recommendation, I think, is an appropriate recommendation for you to include with whatever it is that we then send on to the board and to Jeremy for review.
Okay. Now, Steve, does that get us to where we want to go, at least as far as we are now?
Yeah, look, that's fine. I just say that as it applies to the application itself, Keith and I, again, Keith, feel free to pipe in because I don't want to make it appear I'm speaking.
No,
but
so just a couple things.
Tie the two together, tie the bylaws and the application together so that push comes to shove, even after the candidate is deemed eligible, or whatever that process becomes, the application contains additional information which the electorate, the voters, should know about. And that's really what we're driving at. And it would be unfortunate, I think, a couple of years down the road if some of that was suddenly deleted for whatever reason, even if it was just an innocent error. It was just deleted because people thought it was superfluous. That's
So I
trying to get at.
If I can chime in here for a second. So the two things. Number one, what we're looking at on the screen here, line number 3, where it says as developed by the election committee, I think we just delete that new language. We just take that out entirely because now we've understood and agreed upon that the form comes from the resolution and that there's a process in place by which that resolution can get updated and changed. So I don't think we need that particular language as developed by the election committee. So just application form provided by the search committee. The second thing is what Steve and I struggled with going through the laundry list of possible considerations for board of directors candidacy. Some of the things seem pretty straightforward that there probably would be universal agreement on. And then other things did not seem that straightforward that there might not be universal agreement on, and that you might not necessarily want to make a roadblock or disqualifier for a candidate. But then to Steve's point, maybe you don't want to disqualify a candidate for it, but maybe you want to know about it so that the voters can make a decision, an informed decision. So number one, a disqualifier for candidate, well, we believe has to be referenced in the bylaws. If you're going to say you cannot be a candidate if, that if is going to have to be in the bylaws. If you ask for information on the form that doesn't disqualify you as a candidate, but I don't know, the board, the community, whatever, agree that it's important kind of information that we'd like to know about in order to make an informed vote, then we struggled with, well, how do you put that on the form? So when we get to the form, you'll see there's two different sections. One section lists the mandates as they exist today in the bylaws. So these are thou shalt not pass milestones because they're already codified as it exists today. Then there's another section on the form where they're not mandatory and they're not even required for you to comment on if you don't wish, but it says something to the effect of, these are items of interest to the community. So that may not be the right approach. Don't know. But the bottom line is we were trying to provide a way to address the whole list of things that people were bringing forward as considerations for board candidacy. And it just, in what we were trying to work out was a way to divide and conquer the pile of stuff. And the way we just did it initially was the items on the list that we believe are currently codified are listed as mandatory questions. And the items on the list that are not currently codified, which are subject of debate, are currently listed as optional information. But maybe when the board goes through it, or the council's firm, whatever, maybe some items get moved, or maybe completely removed from the form altogether. Who knows? But that was the effort that Steve and I were trying to put into, is not to discount anybody's input to the process, but to define an organized way of looking at it. And that'll be more clear when we look at this registration form.
Okay.
Okay, let me just, I think that's fine. We can drop down, I believe, down to D. And at the risk of going, I take Jim's words of warning to heart about referring to the daily proposal. But the idea here was to address the process relating to if a candidate must be disqualified for whatever reason. And I'll just note a couple of things. One is it does require the secretary, and I actually made another edit on my copy, so I'll just say that in the 1, 2, 3, 4, 5, I believe the 6th line down, which begins, the sentence begins, if at any time during the time frame of the election process, comma, the secretary is informed, and I inserted the words or becomes aware of a question of eligibility, the secretary, and then the rest of it follows in place. The idea here was the secretary takes the lead, tells the board then is supposed to take action. And most importantly, without even knowing it was going to come up, Keith and I included a sentence or two that gives the candidate in question the opportunity for notice and comment. In other words, if you read the judge's opinion and order, one of the issues, particularly in the opinion, that he cites as a problem was that the board acted so quickly to disqualify the candidate in question. And the candidate had no opportunity to prepare and provide a response. So without putting in time limits, because we didn't put them in, let's just leave it at that, there is a specific requirement that the candidate, hold on, let me just say if I can find it. Board shall then consider and vote on a motion to disqualify the candidate in question after the candidate is given an opportunity to respond to the report of the secretary. So the expectation is, frankly, that the board would be acting in good faith, which I have no doubt to believe that they wouldn't. That the board acts in good faith to provide sufficient time and comment, whether it be in writing or before the board or however they ultimately decide how to do it. We don't specify that. But the candidate has a specific right to respond to what the secretary has found to be a problem. The other thing I will point out is, and I certainly don't mean to demean the work of any secretary, past, present, or future, but the process of going through determining eligibility before you provide the list of eligible candidates to the election committee is, for lack of a better term, sort of ministerial in function. And so if there's to be an action taken to disqualify a candidate, the secretary has the responsibility to bring it to the board's attention, but the board has to act to disqualify. It's not the secretary's action by his or herself. It has to be an affirmative action taken by the board. And again, the notion is this, it's the same procedure that would follow in the case of death or withdrawal and that sort of thing. And so that's where that ties in. We avoided, in part because of our previous discussions about for cause or any reason, those sort of things that came up in comments and in our previous discussions, that we just were not able to provide a suitable list or suggestion. It's sort of beyond our pay grade, if you will, and so that was not done. And the only other thing I would add at this point is just to make it clear that, again, the proposal that we received had a new section 502G, which we also did not. We just deleted it entirely or didn't consider it. It was not part of the charging document that we got from the board, and it really does not, that subject matter did not seem to be appropriate for this section of the bylaw. In other words, it did not appear to be appropriate as to the question of eligibility of the candidate in 502A. I'm sorry, section 502, I should say. And then, so we just never got to that point at all. So that really covers, I believe, all of D.
Question, and maybe Jim can help with this. Do we know what the history is on why it was originally set that the secretary solely by themselves is the one vetting and doing and making sure that, you know, the candidate is truly eligible, or if there's a question in it that it comes out, and then they say no, they're not eligible for whatever reason, why it was a sole position instead of a team, a subcommittee, or I don't even know what you want to call it, but at least two board members working together, because you're putting an awful lot of pressure and responsibility on one person. And since we're all human, one person can make a mistake, versus having, just like we're doing here, multiple sets of eyes on how we're wording things helps, you know, catch some things, you know, something that I see, you know, or I miss, you might see. I don't know where that came in. I don't know if there's a way to or a process to reconsider that part of it. And then that may be a totally different kind of conversation, but I've been mulling that over a little bit, and even in, and I can only use my own personal experience, but even in PTA world, we don't put that responsibility on one person. It's the nominating committee that verifies the candidate. So, Keith?
I'm just going to speculate here, and I'm going to play devil's advocate for a minute. If the board is the one charged with disqualifying a candidate, I think an argument could be made that the incumbents on the board who were competing potentially with that candidate could be considered biased.
Right.
So it may have been the charging for the secretary to make the determination may have been simply for that reason, so that there would be no illusion, no perception that there was any kind of bias involved in the decision. And I think that would be completely reasonable if the secretary had very specific black and white requirements, like a checklist, and it was not a matter of opinion. It was a matter of, do you meet these items or not? Yes or no? And I think part of the problem with what happened here is that some things maybe that were assumed in the past weren't specifically codified in the bylaws. So they were taken into consideration as an element of, practice or tribal knowledge, but without being specifically codified in the bylaws, an argument could be made that the decision was arbitrary. So I think our challenge here is to make sure that whatever in the end we come up with as a community that would be a specific disqualifier for candidacy is specifically documented, codified in the bylaws, and that way there's no doubt as to what criteria is being used to qualify or disqualify somebody.
Right.
And if that's the case, then I think it would be okay for the board to do it, as long as the board acted in good faith and stuck to those qualifications. Done.
So
Steve?
can I interject something here,
If I can.
Keith, with respect to what you just talked about? This revision of section D gives to the board the opportunity to disqualify. And I think that your argument about bias is a good one, and I think it would apply to that decision as well, particularly considering that there may be one or more potential candidates, incumbents, that will become potential candidates. And that was what I would consider a sticky wicket, so to speak, when it came to this court case, is that the judge seems to have accepted the narrative put forth by the defendant's attorney as a correct representation of the facts of what happened. And that representation of the facts is in conflict with the facts as set forth by the plaintiff's attorney on behalf of the board, reflecting our experience of what actually happened. So I think having it be a board vote, I think kind of is a sticky wicket for this on this matter, for the same reason that you articulate that the original decision should not be a board decision. It should be that power and authority should be retained by the secretary.
Well, I was not the author of leaving the power to the secretary. Let me make that clear, first of all. Second of all, my reading of the order and opinion by the judge essentially says that there really was no process in place in the bylaws for the secretary to take the action that she did in fact take. So that's the second thing. The third thing is, I don't disagree with what Keith is saying. The problem is potentially that the secretary taking some action unilaterally Secretary is a member of the board as well. And so the secretary is taking the action and that member of the board is up for election. You have the same bias problem.
Right.
At a minimum. So the answer may be.
But Steve, when I was the secretary, I don't know if this happened with any other secretaries, but when I was the secretary declaring myself as a candidate to run, I resigned the secretary position in order not to have a conflict. And, you know, I believe that that sets a precedent for that, you know, if it hasn't been set already. You know, we have to bear in mind that the directors have fiduciary duties. And if we are
And that's,
You froze up, Colette.
yeah.
So does anybody
So-
know, is the secretary on the board something that is a one-term position? So like, you know, even though the director position might be 3 years, and let's say Colette on her first year was secretary, she doesn't stay secretary for the length of her time? Or is it just a year by year thing that they re-elect a president, vice president, and a secretary part and treasurer part of it? I guess I'm not clear on that part.
Okay, the officer positions can be held for consecutive periods or consecutive years.
Okay.
As a matter of fact, it's been 10 years plus now. We had a first term board member elected president association. And if I recall correctly, he was president association for all 6 years that he was on the board.
Okay.
Let me,
So the secretary could do what Colette said, that if they were up, if it was time for them and they chose to run for re-election, they would then could remove themselves from that position and somebody else who's already in the middle of their term take over, who is not maybe as biased and, you know, in the outcome and all of that, right?
I believe that there was one instance prior to the circumstances Colette is talking about with regard to her personally having to resign. I'm going on what is fading memory. There was one item on that I wanted to comment on, and I completely have forgotten about what it was now, unfortunately.
Suggestion on this. If the issue is the concern about any member of the board who is up for election at the time that this process unfolds,
Okay,
we can include a sentence that says any board member who is running in the particular election may not vote on this particular resolution, and the board's decision shall be by majority vote only. So in other words, if, for argument's sake, let's assume for a moment that one board member has to be recused because they're up for re-election. That leaves 6 members on the board. If you can't get a majority vote, that is, it deadlocks 3-3, then the motion to disqualify is not going to pass. That's it. You're done. So if the concern is the appearance of bias, then that would be the way to solve it. And it applies to the secretary in question as well. In other words, if the secretary is the one for election, then the secretary would be recused under this provision from participating in that in this particular action.
okay, I remember a comment I wanted to make, and that's with regard to how the secretary came about to be the person to do the vetting of the candidacies. That did not exist until the 2008 bylaws, or what I'll refer to now as the current as amended bylaws. The prior bylaws were really vague about vetting of candidates. The only real vetting, if you read the bylaws, would be done by the nominating committee. The nominating committee was given the responsibility for nominating people who were members in good standing. And even the good standing part isn't the complete part of being a candidate with regard to the owner of record part of being a candidate. So, and there's nothing further said other than the nominating committee has to nominate only members in good standing. I'm sure without doing any research, I would have to believe that somebody somewhere in the background did do some other additional vetting, whether it was the then secretary, whomever it may have been during those elections prior to 2008, or some informal vetting done at the staff level. Kind of situation. I have difficulty believing that the nominations that came in, and even then, the nominations were not necessarily, there wasn't truly a nomination from a nomination committee going on at the time of the 2008 bylaws. So the secretary provision appears in the 2008 bylaws, and I cannot add to anything to why it was chosen to be, why the secretary alone was chosen to be the one to do the verification of eligibility. That I was not part of the drafting of those bylaws, and I can't add anything to it. Although I am also have my concerns about the potential problems of having the board be the one to do the
Vetting.
decision making on an ineligible issue. But that's been thoroughly discussed already. Just one other question I have, Steve. We go up to the ballots having been mailed. What happens if after the ballots have been mailed and information is received regarding a question on the eligibility? And that's what happened this time. The ballots, the election was well underway, and there was some information received about possible ineligibility. What happens when that happens? What do we do about that?
Well, as I read the section, and I think, hold on. I think I picked this up again from the other draft that we all received. Yeah, it's the same language that was in the daily proposal. But basically it says the ballots for the election are printed, the ballots will be mailed, the election will continue, and all votes will be tallied. That's, I mean, that
So what you're saying then, or what Jim is asking, is that once the ballots are mailed, there's no more questioning. Is that what we're taking from that? That once the ballots go out, it is a done deal. We said that everybody was eligible because they got on the ballot that was mailed. And then if something comes up after that, then it's got to be dealt with after the election, not in the middle of it.
No, I think that's incorrect, because this next sentence reads, votes for the ineligible candidate will not be counted toward determining the winner of the election. And I believe someplace at the very beginning of section, not at the very beginning, but in subsection D, the large section with the red ink begins, if at any time during the time frame of the election process, the secretary is informed or becomes aware of, et cetera, et cetera, et cetera. So the question that Jim is asking as to what happens once the ballots are mailed out,
Right.
And what happens with the process of the election, essentially, as I read this, says the election continues, but because the candidate has been disqualified, his votes, for lack of a better term, do not count.
Yeah, the goal here, the goal here was to try to address the concern that people had that let's assume that the court came back and said that the candidate was not eligible. Okay. There was still a concern within the community that there were 2 candidate positions to be voted on. And by disqualifying one, those people that already filled out their ballot and mailed it in only got 1 vote.
Right.
Right? Well, how do you deal with that? Right? So then the question becomes, well, at what point do we call timeout and create new ballots?
Right.
And so what Steve was trying to capture here was one option is to simply say, well, if we've already spent the money to print the ballots, by the time we find out that this person is ineligible, we're going to go ahead and proceed, and we're going to notify the community that this name that's on the ballot is no longer eligible, and we're just going to proceed. So you could put something else in there, but the point is, I think language needs to be included that defines where we draw the line.
Right.
So if we've already mailed them, and we as a community want to say, we're going to spend the money anyway. We're going to say, it doesn't matter if we've mailed them out. It doesn't matter if people completed them. We're going to cancel that and we're going to start completely over. I suppose we could do that, but whatever decision we come to, it needs to be in here.
And
Bob?
let me add, if I may, if you'll note in there, it also says this will be the same procedure should a candidate die, ceases to own property as defined in or withdraws from the election. If you remember, when the lawsuit by Mr. Farr was first filed, particularly in some of the social media commentary, there was, well, you're doing things differently. And so the idea was, we're going to treat this disqualification the same as if a candidate were to die, withdraw, or cease to own property, which would also make them obviously all ineligible. So there was an attempt, at least, to make things continuous, if you will.
Okay.
Bob? Oh, you're muted, Bob. Can't hear you.
I don't.
Oh.
Yeah, I see he's muted.
Bob, just click anywhere on the screen and wait for that little bar to pop up at the bottom.
Yeah, there he is. Go ahead.
Okay.
It's up now.
There you go.
Now, okay.
Okay.
Am I okay now?
Yep,
Yeah,
we can hear
okay.
you.
Yeah, my question would be, I understand if somebody dies, that's one issue. But if due diligence and everything else failed until you're halfway through the election and folks have cast their ballot, based on what just happened in this last election, it will be an incentive. Don't vote until the last day you got to mail your ballot. And that's not what we're encouraging people to do.
Well, and I will freely be open. I didn't vote because all of the hoopla in the middle, and nobody knew, were we gonna do a new election process? And because I was at my other place, I would have had to mail mine in. I couldn't wait till the last minute and drop it off at the administration building and put it in the ballot box there. So I didn't vote, and you know, I wish it would have been a little bit more clear for how we handle something that ends up like the situation that we had. So that's why I feel like, you know, it needs to be shared ahead of time that once we mail the ballots, go ahead and vote however you deem the way you feel you want to vote. And then if something happens, at least you've been able to cast your vote for one or both candidates, you know what I mean, that you were hoping to have in there. So I don't know. I just
So I think there is a distinction between so first of all, I think part of our tasking here in this process is to make sure that we clearly define what the disqualifiers are. You know, they got to be very clear. This, and this. If you aren't this, and this, you're disqualified from being a candidate. As part of the application process, the individual has to answer those questions, this, and this. and they sign the form stating that they understand that if it becomes determined at any point that your answers to these questions are not accurate, that we have cause to stop and reassess your candidacy. Doesn't mean that you will be disqualified, but you could, based on, in other words, did you deliberately answer the questions wrong? Maybe you didn't understand what how to answer that question. That would be determined by the individual's opportunity to speak with the board, and state their case, right? But I think that's why it's so incumbent in this process to clarify very specifically what the disqualifiers would be. In this particular case, this owner of record issue, I think, is what muddied the water. But I would also say, we haven't looked at this candidate form yet, that this candidate form really didn't help. The candidate form, actually, the existing one, continued to muddy the waters, right? So I think if we tighten all this up, we tighten up the language that's in the bylaws, we tighten up the language that's on the candidate form, we come to a consensus as a board, as a community, about disqualifiers for candidacy, I think most of these problems will go away in the future.
Right. And that should be our goal. That should be our goal, is to eliminate situations like what just happened. So
yeah, and if you read the judge's opinion, there's a lot of suggestion, if not outrightly stated, that the process that the board followed from beginning to end, from what he calls the tip that was received, from that point on, a lot of it was just outside of what existed as to board procedure, in part because the board didn't have a procedure, because no one ever assumed this was going to happen. So, I mean, that, again, I think Keith's description about tightening it up is apt. I mean, that's what we're trying to do. It may not be perfect, but it does, in theory, it should, if everything fits right, eliminate this almost totally, God willing, from ever happening again. That's what we're trying to do.
Okay, I want to go back to our specific circumstance that occurred in the litigation. And Steve, I really did miss the first, well, it's not the first, that fourth line down where it says, if at any time during the time frame of the election process. That would include the circumstances that we had in the litigation, where a question was raised in the election process midway through the ballot process itself. Under what we have here, it would be my understanding that that information would have to go to the board for the board to consider that disqualification issue, including the notification of the candidate and that part of the process. The problem I have is it doesn't avoid the situation we had here, where we put an uncertainty into the middle of the election process, as Laura, I think, amply demonstrated. Even before the vote, the printed ballots go out. The board can't consider, in my opinion, the board cannot consider this issue in a closed meeting. To me, there's no closed meeting exception for considering election irregularities or not irregularities, but election eligibility, candidate eligibility. I don't see how you would fit that in a closed meeting exception, unless you were going to consider it under potential legal considerations, which is, I think, would be obviously a potential, but I'm not sure that you can really apply it in this particular kind of a situation. So you're faced with having to either consider this in a board open meeting, or potentially not considering it a closed meeting and not being able to legitimately do so. And that, yeah, to me, what would have been better had that tip that came in not had any publicity made to it until after the voting cutoff had occurred. And then the secretary, having had it, hopefully, and it's apparently she did have, would have a decision to make public at that point in time. And then from whatever fallout there was from that would occur. But I'm just a little concerned about what we do in the specific circumstance that did occur.
Well, and also consider when it would have occurred, something like that could have occurred. What happens, you know, and I don't have it right in my memory either, but let's say it's a 2-week voting window, right? Or let's give it the full month. 2 weeks into it, this discrepancy shows up. Is the whole process of the secretary looking at that discrepancy, sending it to the board, all of that going to still occur and be resolved before the deadline to have your ballot mailed occurs? But what happens if that discrepancy shows up 3 days before the last day? I mean, how far are we gonna, I don't know. I can see, maybe I'm looking at worst case scenario, but there would be no way to resolve that within the voting amount, original amount of time to do that full process of the secretary, the board, all of that, to have a resolution in the middle of an election that's already gone out. So I'm kind of in agreement with Jim that in one sense, if any discrepancies show up after the ballots have been mailed, why not let everyone vote and then resolve that at the end after all the votes, the ballots have been collected, and then we deal with whether or not we need to redo the election, add a new candidate, you know, whatever. I mean, there's still a lot of open holes for me in that sense.
Can
I don't know.
Let me just try to, Jim, I don't mean to be flip, but there's an awful lot of ifs. You know, if this hadn't occurred and if the board didn't go into a closed meeting, and if and I actually agree with you. I do. My personal opinion is I think the board should not have gone into a closed meeting. I think the board made a clear mistake by not giving FAR an opportunity to respond. And what is abundantly clear, if you read the judge's opinion, is that the board was given at one point by counsel 5 separate options to pursue as it relates to how to proceed. And they probably chose the worst one they could have in light of the way the court case played out. So I don't disagree with virtually anything you say. If you remember, one of the big issues that came up was whether or not the board should spend, and I can't remember the amount, but I want to say maybe either $10,000 or $20,000 to redo the ballots and do a new election. And, you know, everyone, I don't even know where they came up with the amount, but that's what they all estimated it to be. I have no idea how rooted that was in sound reasoning. But anyway, that's it was either $10,000 or $20,000, I recall, was being bounced around. My thought would be if you don't want to say, you know, the election goes through to the end in light of the board's decision. If you want, and again, this gets maybe a little bit to Laura's point, rather than say, let the board make a decision and then we go through the process of reprinting ballots and sending them out and doing it all over again, you could say, if the board becomes aware or receives the secretary's report, 15 days prior to the date set for election, the board can declare the election to be held in abeyance until it reaches a decision. That way you avoid the cost of having to re-vote, but you still have the board being able to make a decision. In the alternative, what's abundantly clear from the judge's opinion is the board always had the option of letting the election go forward and then taking an action either at the annual meeting or sometime thereafter to disqualify the candidate in question, which they didn't avail themselves of. You know, I look, let's go back to the very beginning, what everybody said. Everyone agreed that A, nobody foresaw this as a problem, and B, there really was no procedure set in place to how to address it. I mean, frankly, Bob's right. I mean, if you go through, you know, the due diligence and the examinations and as Keith pointed out, you tie in the eligibility criteria with the form, there's a good chance this might not come up again. Can't be sure. There's a good chance it wouldn't come up again, but you know, you're trying to answer, you know, sort of all of the problems at once. And one of the problems that came up, and I remember this being discussed at the board meeting, was the cost of a second election. Of course, at that point, it was too expensive, and the board turned around and said, no, we should do a separate election anyway. But if you go by the judge's opinion, and I'm not sure I agree with it, but it almost reads to say every time the board had an option to make a decision, they seemed to make the wrong one. And so, you know, I mean, I'm not saying that's right, but that's sort of the basis. If you read his background section, that's really what he's suggesting. So,
could I interject here? I think you guys are relitigating this. And I think what your purpose here really is to look at the document before you and decide if it satisfies you with respect to what you want to recommend to the board. And I think it's going to serve the association and your committee better to stay on topic.
Well, I respectfully disagree, Colette. I don't think we're not relitigating it. We're trying to come to some sort of consensus about what language should be in this paragraph that addresses all the concerns that came out as a result of the litigation.
Correct.
So in other words, number one, I think it's clear that we do need to add a sentence that talks about the recusal process. So if the language stays in here that the board's the one that's going to make the decision, then I think there would need to be a sentence added that said, should any members of the board be candidates for the upcoming election, they should recuse themselves from the process. And to Steve's point, the vote would be decided by a simple majority. Or if the language stays that it's going to be upon the secretary, that to Colette's point, it should be, I think, codified that it would be a requirement that if the secretary is an incumbent for the upcoming election, that they recuse themselves or they resign the position. So I think it's clear to me that needs to be incorporated into this language.
The secretary, the secretary is going to be a candidate for re-election, actually. The secretary is going to be a candidate for re-election. The secretary should have resigned the secretary position no later than having submitted an application. We should not be down to the point of considering eligibility issues for the secretary to be called upon to recuse themselves. The only other area that issue is addressed, I believe, is in the Elections Committee C resolution, where there is and again, I'm going by memory, there's a provision regarding the liaison. In the past, it has been, and not always, but in the past, it's been practice for the secretary to be liaison to that committee. And I'm not sure that was the case in this last election. I don't believe it was. But historically, there have been instances in which the secretary was the liaison to the committee. Now that's been changed. It doesn't have to be the liaison. In fact, it was stated, I believe, that the secretary was to be the liaison to the committee. That was changed so that that wasn't mandatory. But it also, I believe you'll find in that resolution, whatever the number is, C whatever, that if the secretary is the liaison, the secretary has to resign from being or has to step away from being the liaison of the committee. Now, that's not the same thing as stepping away from being secretary of the association.
Yeah, Jim, just to let you know what happened, there was no requirement that the secretary be the liaison. But the elections committee requested this year that the board consider having the secretary be the liaison, since the secretary has to coordinate many of the election activities with the elections committee. And for sake of efficiency, they would prefer that the secretary hold that liaison position.
Yeah, I understand that. Just as I recall, years ago, the applicable resolution said that the secretary was the liaison, and that was changed to it didn't have to. The secretary did not have to be the liaison to avoid having to change liaisons coming into an election. But anyway, we're kind of off the subject here. The only point I wanted to make is that well before the time of any consideration of ineligibility issues, the secretary should not be involved in election issues of any kind. They shouldn't be involved, can't be involved in the vetting of candidates to begin with.
Yeah, good. I think it's a good point.
Now, if we need to put that in something like somewhere in for example, the duties of the secretary, that the secretary has to step aside from that position if a candidate for re-election or candidate for election, that goes, I think that would go in the officers part of the bylaws. Anyway, we're kind of off the subject here.
So, Colette, what we were really struggling with here was trying to come up with language that dealt with the question of what do you do if disqualifying information becomes available after the ballots have been sent out, after the ballots have been produced or sent out. So you either stop and redo the election or you continue with the election. And with regard to either one of those options, where's the line in the sand? At what point do you say stop? At what point do you proceed? That's what we were really struggling with to try to come up with some kind of language that addressed that.
That should be included
I
in that.
agree that it's a very vexing question. It's the same question the board struggled with throughout this process, trying to figure out how to do the right thing by the voters, by the other candidates that were not involved in the dispute. And, you know, we've said repeatedly, there were no good answers. And we did the best we could with what we had. I'm not, you know, maybe the best advice for your committee is to send forth with your recommendations, your comment about the difficulty of what to do with this. I think, if I remember correctly, Jeremy looked at case law to see if there was any guidance there. There was not. But I think ultimately that may, you know, any language pertaining to that vexing problem may need to be crafted or left out based on whatever advice we get from council. So I think, you know, you guys are putting a lot of time into this because it is a vexing problem, but I don't think there's going to be any simple answer. So, you know, whatever recommendation you bring forward is, you know, going to be helpful to the board, but ultimately we're going to have to abide by or at least consider whatever advice we get from our attorney on that issue.
Yeah, so just, I don't want to belabor the issue, but I completely agree with that. And I think that the bottom line is there is no good answer. But what we do know, I think what we do know, what we understand now, given the judgment, is that there has to be an answer. I think that was one of the criticisms, that because there was not something in the bylaws to provide guidance, and because the board was just left to figure it out on their own, that then they were subject to criticism, right? But if there had been something in the bylaws, right, wrong, or indifferent, that provided them guidance that they were able to follow, there wouldn't have been as much criticism because they would have just been following the bylaws. The criticism would have been of the bylaws and not of the board. So, we could debate this for days, and I don't think we're going to come to a consensus of a great answer to this question. I think we just pick something that seems reasonable, and I like Steve's approach, which is that we use the same process that we would use if it were a death or a resignation of candidacy, or I forget what the other one was, but we just start from there and say whatever process we would use under those circumstances would apply to this as well. I think that's as good as answer as any for right now, because at least it shows a level of consistency for the other scenarios that could potentially happen. That's my recommendation.
Yeah, and Keith, that is exactly what the board's decision was based on, that exact consideration. And so for good or for ill, that's what our discussion focused on. And so I think, that's probably the best we can do and the best that you can do.
Steve, if I'm reading this, is this the right reading of this provision with regard to a issue of eligibility that comes forward after the ballots have been mailed? When the information is received, the board is to meet and make a determination of the eligibility. Is that the way this is supposed to be understood?
Yes, after the secretary informs the board of this issue, however you want to.
Yeah, that starting at the very first line, or not the first, but the fourth or so down, if at any time. Okay. What is the board supposed to do with that decision when it's made?
Well, the way it's written is the board shall consider and then vote on a motion to disqualify after the candidate is given an opportunity to make a presentation. If the motion passes, the board shall make public notice of this, and if printed, you can continue throughout. I mean, it would be, a sort of a step-by-step process, if you will. If at any point the board does not vote to disqualify the candidate, then the election goes through anyway. I mean, that's really it.
Let's see.
So Steve, if I could interject on that. The board, in fact, did give this candidate the opportunity to respond and provide documentation of their claim of ownership, property ownership. And our attorney had several emails and phone calls back and forth with the candidate over several days. And I think the concern, a concern may be how much time is reasonable. And I think when you're in the midst of an election that is close to the ballot deadline, the time becomes more pressing. So I don't know if you guys want to address in this language something about X number of days to resolve it or X number of business days, but I think we can't leave that time frame open-ended, because that, I think, leaves us open to harm to the association.
Colette, if I can, I'm not sure if you heard the discussion. I mean, I have, frankly, rather than set a time frame from the date or the time that the secretary becomes informed and the board acts, My suggestion was to say, if the board takes up this motion to disqualify, and you can put in any time you want to, but let's say 15 days prior to the last day to vote, then the board can hold the election in abeyance until a decision is reached, and then continue with the election, and then you pick up where that is. Look.
Yeah, I'm sorry. I got kicked out of the meeting. I lost my connection in the middle of that discussion, so I must have missed that part of it. So I apologize.
Let me be real clear. I'm not trying to relitigate the case, and in actuality, I agree with Colette that in almost every instance, maybe it was in every instance, the board tried to act in the best interest of the members. I don't have a problem with that. What is clear from reading the judge's opinion, however, is that he never bought that argument. And he specifically focused on the inability of Mr. Farr to communicate with the board. The fact that the attorney got in touch with him and all that, I'm sure all that took place. I'm sure there was a reason for it. If you remember, was it a month or 2 months ago, we went through the whole process of, the secretary having about 2 weeks before certifying the people as eligible candidates to work out some of these differences and all that we talked I think there's plenty of opportunities to get this resolved. The question that comes up, which I think Keith sort of, hit the nail on the head, was in the event you have something that comes up, looking at what happened in this case, you have to have a procedure in place. And that's really what we're trying to get at. If you want to have a time frame from that, the secretary finds X, tells the board Y, and the board acts on, Z, we can do it that way. We can do it, hold in abeyance. Any of it would work to try to address that concern. But I think you have to have a process in place is really what we're trying to get at.
I agree that we need a process, but I disagree in the fact that we deal with that process if it occurs once the ballots have been mailed in the middle. You're assuming that, let's say, out of a 4-week time period, it's going to nice and neatly occur, fairly soon after the ballots have been mailed, or even with 2 weeks left. If this discrepancy shows up 3 days before the deadline to get your ballots in, none of that will be resolved in a timely manner to allow someone who has to mail their ballot in and take all of that information and figure out who they want to vote for and get their ballot in on time so that it'll count. In my view, I think in the best interest, if something like this happens again in the middle of the election where the ballots have already been mailed, we complete the election and then deal with the discrepancy in question afterwards, and verify at that point that these candidates were still eligible, all of that stuff, and resolve it then. I think we're leaving ourselves open for some more issues if we say we're going to resolve it and still be able to, and not extend the voting window, I guess is maybe what I'm trying to say. I'm not confident totally yet, and that's not to say that I can't be swayed, but I feel like there were some candidates, some that fly under the radar on this most recent election that maybe are not present in social media, that got overshadowed then because of the discrepancies that occurred and all of the hoopla and the discussions that occurred about, 1 or 2 particular candidates versus all 4. And when we did our 2 candidate forums and all of that, I still think it wasn't exactly equitable across the board, I guess is what I'm saying. It was a popularity vote in one sense. And part of that is because now all of a sudden, all this attention was given to one specific candidate versus trying to still learn about all four candidates to make a good informed decision. Just my thought.
So Laura, are you saying that?
Refocusing, I'd like to just refocus a little bit on the language you're putting in this, or you're proposing. Please bear in mind how important transparency is to the membership, and whatever recommendation you make, that it include the ability for the board to be fully transparent to the public throughout the election process.
Should we consider adding some language in here, in this section, or maybe another section that gives the board the ability to extend the period, the voting periods, to address that issue, Laura? Is that what you're suggesting?
In a way, possibly, because there's no way for us to predict if some situation, for whatever it might be, happens after your ballots have been mailed. How are we going to nice and neatly say, well, you can only dispute something within the first 2 weeks of the ballots being out, which still gives us 2 weeks, you know. I'm just using those as an example, but you know what I mean, that something might occur right before the end of an election time period, and if somebody was still struggling to decide on who they were going to vote for, you know, do we decide that we have the option to extend? It doesn't mean that it's guaranteed, but it gives a little bit more flexibility to say, well, this discrepancy showed up 3 days before the deadline, and to be in fairness, to make sure everyone's had a chance to get their ballots in, we're going to extend it by 2 more days or something. I don't know. You know what I mean?
My concern is, so it seems to me that one of the options is to say, we're going to deal with all this after the vote. My only concern with that is if it comes to the membership's attention that the board was in ownership of information that was not favorable to a candidate, and that after the vote was used to disqualify that candidate, you're still going to have people upset that that information was not shared with them sooner. Yes, Bob?
I just think, you know, if you qualify the candidate first with what you suggested, Keith, and I've read your application, and all of that is done properly, then this should never occur again. I mean, I've been here 22 years and I've never seen this problem before. And it's a case of somebody interpreted something wrong. I don't think anybody intentionally tried to go around it, but it happened. And so if we qualify people before they run, the chances of somebody having to be taken out in the middle of the process, I think, is very small. But you need a process in case it happens.
Right.
Agree.
Yeah,
Can I ask one question of Colette? Colette, your last comment about transparency for the board, or on the part of the board, I'm just asking, are you suggesting that we also include language to ensure what Jim referred to as there should not be any closed meetings on this issue?
No. I think in this instance, the closed, you know, Jim was correct in assuming that the closed meeting may be justified based on the board's need to receive advice from counsel on making a decision. So I think that those criteria are set forth in the Maryland HOA law, and I think the board is going to have to follow those. So I think you might be running into another sticky wicket if you try to put language about that in this resolution. I think we're going to have to follow Maryland HOA law. on that.
I was just trying to get at what you,
Yeah.
what you meant, that's all, that's fine.
Yeah.
I don't have.
And what I meant when I talked about transparency is that if, you know, I'm not sure where you guys are because I got kicked out of the meeting. I lost my connection during the discussion, but just to make sure that there's no language in this that requires the board or advises the board to withhold from the public information that they will need to consider with respect to eligibility of candidates. And so.
That gets to Keith's last point, I think.
Yeah, I think so.
Okay, thank you.
I don't recall the exact provision, and I'm going to say that I believe that the words that we have here effectively mean the same thing, but that's open to discussion. In public election law, and this goes back to last summer when this all began, when I first started looking this up. If I recall correctly, in public election law, when there is it says something to the effect of when there is a disqualification, a death of a candidate, or a what's called declination, something like that, of a candidate, meaning they refuse to, they say they're not going to take the office if they win. When one of those three occur during the election, it's taken to have occurred after the election has been completed. In other words, in the circumstance that we had this past election, the election continued on, and then you dealt with whatever you had at the end of the election. If I understand what we've got here, that's essentially the same thing. Is that, am I incorrect in that, in saying it that way?
I'm not sure. I'm not sure I know exactly what provision of.
Okay, well, go ahead. I'm sorry, I interrupted you. Go ahead and go back, repeat what you just said, Steve. I'm sorry.
I'm not. Let me put it another way. I'm not sure what law you're comparing this language to. In other words, if you're comparing the election of a member of the House of Delegates or the state Senate,
yeah,
or
it's in the election law article of the code.
Right. So it wouldn't apply to homeowners associations.
No, it wouldn't. No, it would not. I'm not saying that it does. No, I'm not saying it applies to. I'm just asking if what we have here is the same thing. What my understanding of public election law is, if during the election, and it would almost have to be in early voting at this time, a candidate dies or states, I don't care if I win, I'm not going to take office, or is disqualified, the event of declining, disqualification, or death is said to have, or is applied as if it occurred after the election was completed. In other words, after the votes were all in. Despite the fact that it became public, the election continues, and the votes are what the votes are at the end of the election period. And if there's in this case, if there's a disqualification challenge, it goes forth. The way I'm reading what we have here is the same way.
I think that's correct. The only question I have would be in the issue as to what the statute in the election law provision says. What happens if the individual who disqualifies himself or dies or whatever wins the election? What happens then? In this case,
the disqualification has occurred, which is what happened here.
Right, but when I'm,
and then the disqualified person has to take some action, accept the disqualification or not. And in this case, the individual did not.
Right.
It seems to me there's two pieces to this, right? One of them, the first piece is that you just continue with the election. The second piece is the decision for the disqualification, right? So in the second piece, the first piece, you just continue with the election. That's basically what the language in front of you says. We just continue with the election. What's not clear though, or I think maybe is in question, is the decision to disqualify. Do we wait to make that decision based on the information until after the votes have been recorded? Or do we make that decision within the period of time once it becomes available, but we don't announce it until after the votes have been recorded? I think that's the question relative to what you're asking, Jim. Well,
the disqualification is a fact. It's occurred. As I read what we have here, the disqualification would be acted. The issue of disqualification would be acted on by the board as it occurs, or when it occurs, when it comes to the board. So the disqualification would be made presumably before the votes are cut off, before all votes are in. So at the end of the election voting, you have a death, you have someone who has said, I'm not going to serve, or you have someone who has been disqualified, and the votes are with regard to somebody who says, I'm not going to serve anyway. I'm not sure what you do about that. And I don't think we're dealing with that, but we're dealing specifically with a disqualification in this particular case. It's been made, but the clear thing is the decision does not affect the continuation of the election to its final date as is normally scheduled.
Jim, I would agree. That's what the language says.
Okay, I have no problem with that. The only concern I have is with regard to the board of directors as opposed to the secretary.
Okay, I would carry it. Let me just finish. Carry it a step further, which would be in the. I think I'm correct about this. In the event that a candidate to use your comparison, candidate for General Assembly dies and wins the election for a seat, what then happens is a vacancy is declared, and there's a process by which that vacancy is filled. Yeah. Actually, by order of the governor, as I recall. So now that issue is not addressed here. I mean, if there's a vacancy, what do you do? That issue is not addressed here. So I'll just.
It is addressed elsewhere in the bylaws, vacancies like that.
Okay, so the remaining question that you just identified is whether it's the action of the board or the secretary that triggers, whether it's the action of the secretary by himself or herself, or the action of the board upon receiving notice from the secretary that a problem exists. Go ahead.
Well, we are, if I understood correctly, the intention was to address that by not allowing votes to be counted by an incumbent who's running for election.
Yeah, I can put that in. That's not a problem. And I could even carry it a step further. I can even put in a sentence. I'm not sure this would be the appropriate section of the bylaws, and Jim, you may want to direct me to a different one, but I could put one in there that essentially says that if the secretary is running for re-election during this process, the secretary shall resign as secretary and a new secretary be appointed by the board, or whatever process the board follows. That covers both concerns we have. Or either one is suitable, or the two taken together would be suitable. That's fine.
Well, I would rather see it without going back and look at the officers part of the charter bylaws. I think it would be more appropriate in the duties of the secretary that there would be a resignation of the position if the secretary is running for election. Right. That's my view. Let's just put it that way.
Okay.
Okay, we kind of need to keep moving along here. It's getting to be one of our longest meetings. on this particular section or subparagraph D, are we not pretty well down to the point where something has to be written in there that the board making, the fact that the board is making the disqualification decisions, that there has to be a recusal of members who may be, if members on the board are up for re-election, their votes will not be counted on a motion to disqualify.
Right. Any board member who is a candidate for re-election during this particular, however you phrase it, the timeframe of the election process may not vote on any motion to disqualify.
Okay,
And
the question is that okay with the rest of the committee?
Agree.
Got a Keith up, thumbs up. We
I'm good.
lost Laura. Laura, you
Nope,
still with us?
I'm good.
Okay.
Yeah, my question is, let's go back to the application. If we agree with the application, and I agree with what you just said, it makes sense.
Right. I do think the next step is to look at the actual application that we're going to recommend.
Okay, Steve, you got that? Okay.
yeah, I'll try to put together some language in the next 24 hours or so. And get it.
All right, we guys really need to move along here. It's 3:23 on my computer. We're into the form. I guess, Keith, you want to pick up on the form for us?
Yeah, Josh, could you put up the original candidate form, please? No, that's mine.
It'd be the
That's
attachment
yours?
of N09, Josh.
Okay, there we go.
Yeah, you gotta go a few pages back.
It's an attachment, so it's going to be towards, yeah, there you go. There you go. You just passed it, I think.
Yeah, it's
Attachment.
skipping on me. I went too fast. The computer doesn't like it.
You got the one that's in, might be the one that's in Colette's.
My goodness, it's all lined out.
Let me get one from the website.
Well,
Okay.
so we're not going to spend a lot of time on this, but I just wanted to show what the current form looks like. And you can see there under the issue of property where it says, please attach supporting documentation if OPA records do not show you as owner of record. So I think that was problematic that it referred to OPA records instead of county records. But then if you continue to scroll down, it has, some brief lines for bibliographical, biographical type information. There you go. Biographical information, some subjects of interest that maybe voters might be interested in to help make a decision. Keep scrolling. And then there's a paragraph which has a little bit of meat in it, which says, I'm willing to serve, I'm eligible. And the only thing in here specifically that it calls out, other than a reference to 5.02, is the requirement about, I understand I can't be an employee of Ocean Pines. So to me, this is not a very useful document. I think this document would be more useful with some modifications to it so that it could then become the vetting document for each candidate, right? So Josh, could you go to my version, which you've got up there at the top, one of those candidate tabs? No. Nope, one more. That one. Okay, so these are just some suggested tweaks to this document that I think would make it more helpful. It'd be more informative to the candidate. So to me, it serves two purposes. It informs the candidate of the hard requirements that are in the bylaws and of the use of the form, the information on the form, And it will potentially also end up informing the community if this information is released to the voters. So and I'm not sure if we're even still on the issue of record of address, but Colette had made a comment about how much work it could potentially be for the secretary to dig into these records in some cases to determine who was or was not, ownership, how much ownership, et cetera, that it could potentially be a significant workload. And so one of the things I was trying to keep in mind is, how do we simplify this so that we don't find ourselves in a position to have to hire a paralegal full-time to go through all this stuff? So I thought with regard to the property issue, we would just make it really simple and say that if your legal name does not appear on the deed, it's up to you, the candidate, to provide whatever documentation proves that you are in ownership of this property. It's on you. You go do the research, you talk to who you need to talk to, you attach whatever documentation to this candidacy form to prove to the process that you are, I forget the terms that Jim used, but that you're, owner of this property. In other words, put that on the candidate and not on the secretary to figure out. And then, email address, phone number, et cetera. If you could scroll down, Josh. Yeah, so right here. So this first section, a yes answer to any of the following make you ineligible as a candidate for the board. So to me, this is where you would extract from the bylaws the current approved, documented disqualifiers that already exist. And you put them right on the form, because again, it's the form is being used to inform the candidate. So they don't have to go digging through the bylaws and try to read it and understand it. You just put it on the form. Are you an incumbent director? Are you ineligible to vote per 301 Charlie? Are you currently an employee? Now, the only one I put on here that's not currently in the bylaws is that second one. If you have a familiar relationship through marriage, parentage, etc. Because Steve and I, when we talked through these, that seemed like the most likely to get the most amount of support to be eventually included. The rest of the disqualifier options that have been tossed around and discussed and brought up, I put in a separate section here. And I'm not saying that this needs to be on the form, but I didn't want to exclude them. Steve and I didn't want to exclude them from the conversation and the potential consideration of the board, because some of these items came from board members. So, these are the other issues that were brought up that for various reasons, Steve and I didn't think would survive the scrutiny necessary to be a disqualifier. That doesn't mean that the board and or the community can't vote to include them. They certainly could. And that was just our opinion. But I put them here under the second section of, you don't have to answer these. They're not mandatory. You don't have to address them, but these are historically issues of concern to the community. And these are the topics that have been discussed, social media and in different articles over the past almost year now. Hey, could you scroll down, Josh? And then finally, I thought, and so this section here about the biographical information, I always have kind of a pet peeve with forms that ask you novel type information and they give you 2 lines to write it. So I think it would just be more appropriate here to say, following types of information are suggested. These are helpful for us to understand you. And you can write them out on whatever document you want. You can write a Bible if you want and attach it to your candidate form. Whatever you wish. We're not going to limit you to a line or 2 lines on this. And then the next part, which I think is the most important part, is the disclosures and agreements. So in the disclosures and agreements, we specifically state the best we can, and of course, this would have to match the bylaws, what moving forward means for your candidacy. and what you agreed to and what you're responsible for. And what you're responsible for and you're agreeing to is providing accurate information, right? And that you understand that if it comes to the secretary's attention that some of this information has changed prior to the reading, and I put in here prior to the reading of the vote, that obviously was based on the other language that we had. Because after the reading of the vote, I was thinking now you're a potential board member and maybe there's a separate process for dealing with that. So don't focus too much on the prior to the reading of the vote part, but here's where we would put the agreements that you're signing up to, that you did your best to answer the questions truthfully and honestly, that all the information is accurate and correct. You understand that this information is potentially going to be provided to the public and the media, and that you agree to familiarize yourself with all the Ocean Pines community governing documents, uphold them, and honor fiduciary responsibility. Oh, and that number, there's a second one up there, that should any of the information on the form be found to be incomplete or inaccurate at any time prior to the reading of the votes, the board shall have cause to rescind your eligibility as a candidate for the board of directors. And I worded it like that, the board shall have cause, because potentially the candidate may come forward and explain the situation and the board go, oh, okay, well, then that's not disqualifying and continue on, right? So it's not saying you will be disqualified. It's saying that there's a possibility you could be disqualified. So anyway, I think it's important that this form be used for two purposes. One, to inform the candidate of what the bylaws say, and two, to get the candidate's awareness and agreement to how this is all going to work out down the road, if should any of this information you provided be determined to be inaccurate.
Josh, can you scroll back? I'm sorry. Josh, can you scroll back to where the a yes answer to any of the following questions was?
This is what you're looking for?
Keep going.
A little bit.
Oh, there we go.
Yeah, and I apologize because I was sort of out of pocket for a few days over the last week or so. I actually jotted in here where it says a yes answer to any of the following questions makes you ineligible as a candidate for the board of directors. I wrote in on my copy, pursuant to the Ocean Pines bylaws.
Yes.
Only because I'm still sort of hung up, if you will, on the idea of trying to tie the form to the bylaws provisions that we've been talking about. So I thought that would be helpful. And then, Josh, if you could scroll down to the next section, comment on the following questions not mandatory. The provision, let's see, it'd be the fourth one down. And I think, Keith, you and I discussed that a little bit. Are you now a plaintiff against, or do you have immediate plans to bring a lawsuit? The notion of immediate plans to bring a lawsuit, I found to be problematic. My view is it's almost impossible to know, and I'm not sure it's even fair to ask someone if they have immediate plans or any plans to bring a lawsuit against the Ocean Pines Association. If it was me, I would not have included that language. And I'm just throwing that out for people to consider. And then in the last issue on disclosures and agreements, Josh, if you could scroll down again. Keep going. Yeah, right there. The language that Keith just highlighted, the number 2, in the second line there, where the board shall have cause to rescind your eligibility, I actually would have included the words shall have cause to consider rescinding your eligibility, to make it even more give a little bit more flexible as to how the board might act. I also, on the one below that should any information provided on this form be found to be incomplete or inaccurate after your election to the board shall have cause to consider removal.
I agree with those. I agree with those.
Yeah, and then one more, the one below that, that if you are approved as a candidate for the Ocean Board of Directors, information provided on this form will be available. I inserted to association members, comma, the public and media. I just thought it'd be helpful if we had the members listed first, that's all. I mean, they're clearly the public. I don't disagree with that, but I would have included them separately. And those would be my suggestions.
Okay, anybody else have any comments on this?
Yeah, I have a comment. Let me get back up to the top. So I'm looking at the section, the first section, applicant's legal full name section. And the only comments I have about that are, first of all, I think it should be required that the applicant attach a copy of their state issued identification card. We ran into some, part of the testimony in the case, recent case against OPA was that the plaintiff had represented himself to the membership department as meeting the qualifications to become a member. And the record and that information did not match OPA records. And so had it been required that the state issued ID be presented to prove identity as the person who was on the deed for the property, that would not have happened. So I think we do need to have the state issued ID attached so that we're sure that the person that is submitting this application is the same person whose name is on the public record. And then the second comment I have, where it says Ocean Pines street address, I would say that should be property address, because some people own more than one property. And in the case of the year that I was sued as secretary, the applicant owned a property where the assessment was not current and was claiming membership based on another property. And so I think the applicant needs to declare the property that they are using for the basis for applying to become a candidate. And then we won't have to go digging to find, do they own other property? Does that property qualify them or disqualify them? I think that, just as a former secretary, that would have made life easier for me in considering the application.
So should it say all Ocean Pines property addresses?
I think so. And one of the issues for people who own multiple properties is that each property entitles them to membership rights. And so if the individual is in good standing, so to speak, based on 4 out of 5 of their owned properties, but not the 5th, I think we would need some legal opinion as to whether they would be considered disqualified to run. And so I think it would, the iteration of this that I did, which is not nearly as good as yours, I think you did a terrific job on this, Keith. I was seeking that the applicant list all properties owned so that, if that becomes an issue, it could be addressed without a lot of digging and tipster information, so to speak.
That's a really good point. And I think that, again, that really goes to putting the onus on the applicant to divulge the information necessary to do the vetting, so that you don't have to dig. You ask the questions, they provide the information. I think I would have never even thought of that. So I think that's a really good point.
Steve, you got a question, do you?
No, I provided my suggested edits, and I just say I apologize to Keith because I just say I've been out of pocket for several days. But
Okay,
I thought did I bring my hand down? Yeah.
yeah, your
Yeah,
hands,
Jim.
your hands up.
Yeah,
Okay,
Jim, the other
Sorry.
comment I'll
Okay,
make,
go ahead.
the other comment I'll make is if attachments are suggested versus required. And so I think in looking at the things that you're advising or requesting or asking to be attached, I think it should be specified if they're required as part of the application, because that also, I think, can become an issue down the road. So just.
Good point. Good point.
Okay, any other comments, Bob, Laura, for example?
I agree with what was said. With those changes, it makes sense to me, and it should eliminate the problems that we just encountered.
Laura, you still with us? I don't see her or hear her.
I see her. She's there. She's not saying anything. Lori, are you saying anything? Are you on mute?
Yeah, I see her.
Yeah.
I don't see her face.
No, she's
Okay,
there.
I
Her microphone's
have
on.
I have no additional comments, Keith. Okay. I don't know
Good
if
job,
that was- Okay, we need to summarize where we're at on these two items. First of all, on going back to the bylaws text part, if I have got my notes correctly, the only thing that would be there's a change in the search committee, or not search committee, subsection C of whatever it is, 502, deleting the parenthetic as developed by the elections committee.
Right.
And other than that, I would give a different, not different, my own view of the owner of record member situation in the bylaws. And in the form part, there were several suggested changes which Keith has, and I think we've all agreed to. Does anybody want to add to what I just said as a summary of where we have gone with these two documents?
Well, I do have to provide language to everybody on sub D dealing with rescission. If a board member.
I'm sorry, I completely missed that. I have notes here, but didn't make a specific note. I'm sorry, you're correct. Okay.
Jim, in deference to you, I'm going to include in that language in D, language relating to the secretary. If the secretary is up for re-election, we can decide at a later date where it belongs. But
Okay.
in saving time, I'm just going to give you some language to run with.
Okay, that's fine. Okay, now what we do with this, Colette, are we to submit this to you and it goes from you to the board or to Jeremy? How are we going to handle this? Is she?
She's on mute.
Sorry, I was muted. So submit it to me and go ahead and submit it to Jeremy and the board,
Okay.
along with a discussion topic form for our next.
Okay, then if Steve and Keith, if you forward that to me, send copies to everybody, and we'll wait a brief period for any further review by the committee, and then I'll send it on to Colette, if we can do it that way.
And Keith, I'll give you my quick edits by email, just so I just did orally, if that's okay with you. On
Yeah,
the floor.
yeah, and I'll make the changes to the candidate form that we talked about and that Colette provided, and then provide that as well.
Okay.
Okay, I know we're really running late, but we need to spend a couple of minutes at least on the next agenda item, and that's the material that Colette has prepared, and I don't propose that we go any further.
Yeah, and I would say that you can trash my candidate verification draft because Keith's is far superior.
Okay, so that would leave us with the text of the M09.
Yes.
Okay, Josh, have you got that information you can put up there?
What's the file title? Is it M09
well,
revisions?
M09 one
Draft
two,
revisions?
yeah,
Yeah, that sounds right.
version 2. Yeah.
Okay, the first couple of pages that don't have anything on them. It would be page 3.
Yeah, and I see there's a typo on page 3, which I'm fixing. So I just want to preface this by saying that this is an attempt to incorporate the things that you all have suggested as the recommendations that you would be making to the board. And so I hope I got it right. Let me know if I didn't.
Okay, go down to 8, paragraph 8, 8A, I guess it is.
Yeah.
Okay, the change there is that the secretary shall use the Worcester County land records to verify ownership. There was some question about using the State Department of Assessments and Taxation records.
So just real quick here. Do we want to repeat 5.02 here, or do we want to just reference it?
I don't have any problem with referencing it, but
because I know when I first came to the committee, one of the things that we were struggling with was that we had same information that was discussed in the bylaws versus the resolutions, and that they didn't match. And if you changed one, you had to make sure you changed the other. And so one of our early efforts was to try to reduce some of that by just simply referencing back. And if we know that the bylaws take precedence over the resolution, it seems like to the extent that's reasonable, we should just reference the bylaws rather than repeat it here, because then we're going to be potentially struggling with making sure that they match, that they're either got to be an exact, copy and paste, or, we're going to run into a similar situation.
yeah, I agree. But one of the considerations here is that the current bylaws do not reference the Worcester County land records. The intention, correct me if I'm wrong, Colette, but the intention is to get this out to make it applicable to the current upcoming election.
Oh, I see.
And we don't have that reference in the bylaws at the present time. That is the current intention, is it not, Colette?
Yeah, that is correct. And so
Okay.
the risk we run is if we run into a challenge, if this is inconsistent with the current bylaws, we could have a problem. We are hopeful that as Bob pointed out, that the changes in the candidate verification process will obviate any challenges that we're kind of tightening up all of our loopholes in the candidate verification process. So
I understand now. I understand.
Yeah, and on the making this applicable to the upcoming election, kind of looking here ahead. Well, let me hold that comment. Let's go on to the next page, Well, it actually goes down to the bottom of this page. I'm sorry, don't go too far on me. There we go, stop. Well, don't go any further, that's good. We have the completed candidate registration form. I'm not sure what that added. I guess that title got in there at this time. It attached this as provided, attachments as required, okay. The next item on that next page, V, this is a new item. It clarifies that the secretary can ask for information to better understand, it may seek information from an applicant regarding the form, but it's not to grant any further time to complete the form or correct information on a form that's been submitted. Any comments on that?
What's the purpose of that? I'm just, I mean, I know what it reads. I'm just curious what the purpose.
At one point in time, there was some discussion of what could the secretary do if there was something wrong on the application, or allow a time to correct something that was submitted wrong, or even give time from the period of May 15 until the list of eligible candidates has been given to the elections committee. If that time could be allowed to, if the secretary, in other words, if the secretary has not sent over the list of eligible candidates, that another applicant has that opportunity to provide the form or information to the form that was due back on the 10th. Well, as a cut off of the form. The form is what you put in on the 10th, and that's it. That's basically what it means.
If I could just ask a question, if you seek the information and the information resolves the reason for seeking the information in the first place, someone, either whether the candidate or the secretary, it seems to me, would have to provide some sort of document, an addenda, if you will, to the application. No, am I wrong?
I can see that that's a possibility. Yes, without dealing with some specific circumstances, I'm not sure.
Well, I mean,
how much further I could say anything.
I mean, I read this as saying that the candidate cannot edit the form after it's been submitted to the secretary. But if the secretary has a question and the form becomes public and there's nothing that indicates that the question was answered in a way that resolves the secretary's concerns, what have you done to the candidate? You've left him sort of hanging, no?
There would have to be some kind of documentation. If the secretary's needs some clarification of some kind, the secretary would have to document it in some manner.
Yeah, as long as the document, whatever satisfies the secretary, is made part of the record as well, that's fine. It just seems to me the answer has to be somewhere around either the candidate can make the change or the secretary can say, in words to this effect, after consultation with the candidate, this issue has been resolved without the need to go any further or without questioning his candidacy or whatever term you want to use.
I'm trying to think of.
So what could be added, I guess, is a statement that the secretary will attach to the application a report of clarification as appropriate.
Yeah, or resolving the question. What? Yeah, anything that would. Yeah, that would.
In what, for example, in somebody's handwriting may be illegible, and so And I mean, I tried to make this so it had to be typed, because I'll tell you, I saw a lot of illegible handwriting when I was doing. And so that you may or may not need to really resolve with the report, unless it's information that is crucial to the processing of the application.
Okay, Colette, I'm going to ask you a question here but before I do that, there's something that I should have mentioned at the beginning of our discussion here. After our past meeting in December, thinking over several things about what we had been talking about, including such things as not notification, but disclosing application forms and the issue of what to use for reference of property ownership. And I suggested to Colette that there were some changes that could be made to the resolution, as well as the form that we're setting aside, application form we're setting aside. So I basically initiated this consideration of changes to the resolution and the form for the upcoming election to try to avoid some of the issues that have occurred in this past election. So my question is, Colette, do you want to add words into what we're talking about here, or should I go ahead?
No, I'm adding them in as we speak.
Okay.
Okay, so I'm adding in here, the secretary will attach to the application supplemental information that resolves any questions.
Okay.
How's that sound?
Any comments on that? Okay, moving right along. The next one down there is in subparagraph C. What did we do there? Shall notify prior to submitting eligible candidates. The reason for a rejection shall be included with the notification. Okay, that's wasn't there, although at some point in time I know it was considered.
And in practice, it was given.
Okay. Subparagraph D is basically all new language. This deals with once the list of eligible candidates goes to the elections committee, the following shall be released to the public. Probably should be the members and the public, as was made, a comment was made on the form that Keith had prepared. One is the list of eligible candidates. That's been there. The other is that the registration form of each applicant is going to be released. Now, if an applicant is ineligible, the reason for disqualification will be noted. In the form that you had prepared, Colette, it only referenced releasing the eligible candidates application form. I had missed that in my proofreading, but do we want to release the ineligible candidate as well? I think that's
the ineligible candidate information. You mean the name and the reason for disqualification?
Yeah, the application and the reason. Yeah. The form which the applicant would sign that you had prepared only listed the eligible candidates application being released.
Yeah, and that makes sense to me. I don't know that we need to put forth the reasons for disqualification and the list of disqualified candidates, but you guys, what do you think as a committee? That's just my opinion.
If a person's disqualified, let's say that well, again, it kind of goes back to if our form is succinct enough, then there should be no surprises, right? But let's say they filled out the form, they didn't fully understand something, and during the vetting, one of the hard disqualifiers was discovered. then they're notified and said, I'm sorry, but you don't meet the qualification requirements because we have this bylaws requirement. And theoretically, they're voluntarily withdrawing their candidacy, right? Because you're telling them they're disqualified. So if they're voluntarily withdrawing their candidacy prior to the announcement, should it still be released to anybody? It seems to me like it shouldn't.
Yeah, I guess in practice this year, we did have a candidate that voluntarily withdrew. And I think that candidate voluntarily made it public at the time of withdrawal. But
Well, if the candidate does it voluntarily, that doesn't affect subsection D here. It's really what the secretary and or the elections committee, it's their task. It does seem to me that this takes place upon submission of a list of eligible candidates. So for the purposes of the voting public, their only interest is going to be in the registration forms that the eligible candidates have submitted. If you're declared ineligible, you're not going to be on the ballot anyway. And now that person may seek other redress. They may go to court, who knows? But in terms of what you're doing, in terms of the process really only involves eligible candidates, not those that are ineligible. So I think I agree with what Keith is saying. And if I may, just to go back to the A1 where the Worcester County land records, understanding that language may change in part because of Jim's suggestion earlier, I would include citing Maryland Department of Assessment and Taxation records. First of all, as I understand it, those are computerized. Those are the easiest ones to get, as opposed to going over to the county clerk's office. And they would be the ones that would be most immediately available. And potentially that would solve your problem. So
you're suggesting that I add Worcester County land records and or SDAT?
Yeah, Maryland Department of Assessment and Taxation property records. I'm trying to remember. Hold on, let me see.
Yeah, it's State Department.
State, yeah, it is State Department.
Assessments, taxation.
Yeah. That'd be my suggestion.
Okay, so are we in agreement that we're going to, on the very last item of the text of the resolution, it's going to only read that the registration form attachment B of eligible candidates will be released to the membership and the public.
Yeah, each eligible applicant. I think you just have to insert eligible.
Yeah, okay, that's good.
Okay, and while I'm thinking about it, the form that Keith sent does not have a place for the applicant's signature. I'm assuming that you would expect a signature to be affixed to the application.
You're correct, Colette. I originally tried to do that in Adobe, and it had all of that stuff. And then when I gave up and I did it in Word, I just didn't copy over that signature section. But before I send it back out, I'll put that back in there.
Great, thank you.
Signature and date.
Yes.
Yeah, it's basically the same bottom information that's on the existing form that has those 4 blocks and the different, I'll put all that back.
Yeah, that all needs to be there, those documentation blocks. Yes, thank you.
Okay, did we finish up on that D II? It'd be each eligible applicant.
Yeah.
Right. Yes.
All right. Anything further on the resolution M09 issue? Okay, guys and gals, we're after 4 o'clock, and I think it's appropriate that we we call an into it at this time. It's been 3 hours plus now that we've been working on this, and I think.
Yeah, thank you guys so much for
Now,
getting done what I need for the January meeting.
let's go to the remaining agenda item is the next meeting. I'm going to suggest 2 weeks from now, same time, same place, same way. Does anybody got any further comment? Or any further suggestion?
Talking about the
The
20,
21st?
Be Friday, the 21st. Yeah.